What's up, everybody? Welcome back into another episode of the Lawyer You Know podcast. We have week one in the books in the Karen Reed trial, and we haven't heard from my dad yet. What does he think? What are his thoughts? Who's winning? Who's losing? How are the lawyers doing? What has surprised him so far, especially because he didn't really watch the entirety of the first trial? We're going to get all that information today. So let's get into it. All right, Dad. So we are here 5 days in, 2 half days, basically. Thursday and Friday were half days. And we've had a lot of witnesses, but we're going to go all the way back to opening statements at the beginning of the week. I think it started on Tuesday this week. Alan Jackson for the defense, Hank Brennan for the prosecution. Neither of them did the opening statements in the first trial. What was your thought about each side's opening statement?
All right. First, you've got to take a look at what the purpose of their opening statements. A prosecutor's opening statement has a different purpose than the defense lawyer's opening statement. So, Brennan's opening statement was, I am clear, I am concise, I am organized, I am methodical. I am going to carry you through this step by step so you understand everything because I have the burden of proof and I'm going to fill in all the blanks. So let's go through it. He these are stylistic criticisms, but I think he moved around too much. I think he would have been better off if he was a little more stationary. And I also think his other big flaw was not mentioning Proctor and dealing with Proctor in his opening statement. Big, huge flaw. But the fact that he really had his timeline memorized, the fact that he had the dates and times down, I mean, really had them down, didn't need to use notes, and he appeared very organized and methodical. When he finished, again, looking at a jury that had not heard the first trial, so this is, let's presume this is new to them, this timeline. When he finished, he had the appearance of being organized. He had the appearance of knowing his case, and he had the appearance of knowing what he was doing and what he was going to present and how he's going to present it. So I think he gave a good impression. As time goes on, I think he's going to get bit by the Proctor issue because obviously they didn't know that in the when he was giving his initial opening, but that's going to bite him later on. So
Yeah,
that's my impression of Brennan.
Yeah, I like moving around a little bit more, maybe than you do. I mean, I like to walk around the courtroom. I don't know if you mean he meant move too much, but I don't
I mean,
necessarily like standing behind the podium. There is a microphone, and Jackson did a lot more of that, so it was easier to hear for the public, which I do think is a big part and a big thought in the defense's head that maybe is not as much in the Commonwealth's head. And yes, he had all that memorized and had it to a T and said it all, but will it all be correct? Or will it end up crumbling as the case goes on? That's something that remains to be seen.
right. Well, my critique was merely for his presentation, not for whether or not he's going to be able to prove it.
Right.
But just his presentation. Yes, I think a little moving around is okay. In fact, I like to move around. I do. I just think that he overdid his moving around. He would have been a little better off if he'd have been a little more concise. But again, just presentation. I think he did a good job of presenting what a prosecutor should present when he's talking before a jury, and I think he did a good job of that.
Okay. What about
Okay.
Alan Jackson for the defense?
All right, Jackson, defense lawyer, different purpose. Defense lawyer is taking shots. All a defense lawyer has to do is prove a reasonable doubt in any one of multiple areas. He doesn't have to prove the whole case. He doesn't have to prove it beyond a reasonable doubt. So what Jackson did smartly is Jackson focused on and kept repeating certain themes. And a theme is important for a defense lawyer. So Jackson's theme of no collision is not going to leave the minds of those jurors. They're going to remember that through the entire 6 or 8 weeks of this trial. And they're going to look at that and focus on that. And I think he wanted to leave them with the impression that there's a lot of holes in what the prosecutor said. And I'm going to show you why there are holes. I'm not going to fill those holes in. I'm just going to prove the holes. And that's what he did. And he did a good job. I enjoyed his presentation, I guess, just in the theatrical sense of entertainment. He was a little more entertaining in his presentation, and it was easier to concentrate on what he was saying and not kind of waver off and think about, what dinner is like, which you could have done during Brennan's presentation.
Yeah. I think he was definitely more engaging, and definitely said more of the stuff that would make you go, and the jury's like, wait, there's more. And hopefully, what it does as a defense attorney, what you want to do is don't just take everything the prosecutor says as truth. Take it a little bit with a grain of salt and wait till you hear all the evidence. Wait till you see the gaps in the evidence, the holes in the evidence, the problems with the evidence, and what they actually can't prove. So I think he did do that as well to make sure the jury's not just, because sometimes jurors can come in there and just say, everything the prosecutor said is true. Everything the cops say is true. We trust cops. We trust prosecutors. Okay, guilty. And that, as a defense attorney, you got to make sure is not going to happen.
Right. And so but I don't fault Brennan for not being theatrical.
Sure.
As a prosecutor, it is better to be the professor
Mhm.
in the room, because your professors might be boring, but you really want to know what they have to say, and so that's what the prosecutor is supposed to do, and I think he did a good job of that.
Yeah. Yeah. I agree. Okay. Next, let's talk about the order of proof, which is what we lawyers call the order of witnesses and exhibits. And in this case, it's not just all witnesses, right? They have witnesses, they have tapes they're playing, they have texts they're reading, they have pictures they're showing. So, what have you thought about Brennan's order of proof as a prosecutor? He went through his opening statement, starting with the first responders, America's heroes, Nuttall. That's the first witness he puts on the stand. Then it's Kerry Roberts, what happened 5, 6 a.m. and beyond. He didn't start with what happened earlier that night, going to the waterfall, which is kind of what Lally started with. So, kind of a little bit of a different order of proof. What have you thought about it so far?
Well, there are different theories, and you've got to, as a prosecutor, you've got to take a look at your case and decide: do you want to front load it or back load it? Do you want to uh, lead the jury into a final crescendo at the end, or do you want the jury to have an opinion, a strong opinion, at the very beginning of your case that jury carries through as it goes through the evidence? I think that Brennan has decided to do some front loading here. I think that he has decided he wants to give the jury as many of the facts that he can to prove his case before you get to all these experts and all the mumbo jumbo and the theories that are going to come later, the scientific theories and
That
what
are
they
going to be
happen
better for
later.
the defense, frankly.
You're right. So that's why he is front loading this so that by the time you get to experts, the jury may have already said to themselves, well, the facts prove this case. I don't care what the experts say. And that's very important because books, really, you can read a lot of stuff that's going to say that when you have competing experts in a case, juries will a lot of times totally ignore the expert testimony and go with the facts. And in this case, he not only has this factual testimony, which again, there's a lot of, I shot the clerk testimony in this. What was the inflection? I hit him. Those kind of statements, or did I hit him? What did she actually say? But in this case, you've got the audio from the interviews, and you've got the text messages. So you've got some things that really can't be questioned. That interview, that's her words. That's her words live, and that's really strong evidence. So you can question, did they say it 2 times or 3 times? I know we'll talk about that, but you really can't question what she said on that
Well, you
documentary.
can. You can because you can question the context. And we're going to talk about that in a second, though. I don't want to jump ahead. Right now, we're
Okay,
just purely sticking to what you
okay,
think about the order of proof, the
okay,
witnesses, the evidence, the way that he's setting up the case.
sure.
That's what I want to, because I want to get into all of those things, but they're all conversations in themselves.
Right. And okay. What I'm saying is he
Mhm.
is doing a front loading of the facts in this case in order to get the jury's mind set on what happened so that the jury thinks they know what happened. And they may even think, all right, I can listen to these experts, but I already know what happened and I already know who's guilty. And that's what he wants to do. And that's what he's doing because he really, I think he has to in this case. It's not a case where he can wait for the jury to make a decision at the end of the case. I think he needs to try to get their minds right at the beginning.
And I also think he's doing his best to try and make Karen Reed look bad and
Right.
try and make the John O'Keefe, the friends, the family, the witnesses look good, sympathetic, this is who you have over here, and this is this person you shouldn't like over here, Karen Reed, which is a very common plan and theme for prosecutors. We call it the generally bad guy rule or the generally bad gal rule, where they just try to stack all this stuff that makes them look bad. It's judges are supposed to balance what comes in and what doesn't, but I definitely think that's something he's trying to do early on in the case.
Oh, absolutely. Like I said, he's front loading it.
Yeah.
That's what he's doing.
So the next thing that a lot of people are talking about is Alan Jackson's style on cross-examination. It's some people have called it bullying. Some people call it assertive and controlling the witness. What have you seen so far stylistically with his cross-examination? How do you think it's working? Do you think it's effective? What do you think a jury is thinking when they hear and see that?
I find it hard to criticize his cross-examination, to be honest with you. He's the cop that's, again, I'm fairly aggressive in cross-examination too. That's the style you've got to have. You're out there fighting for your client, and you've got, again, let's face it, the government, the Commonwealth. You've got this powerful entity that's on top of you here, and here you're just this little defense lawyer all by yourself, and you've got to fight all of these guys and all these people and all these attacks and all these police officers and all these firemen and all these parents. You're out there fighting for your client. I think he's doing a terrific job in his demeanor and the way he's conducting it. I think that I have no problem with the style, and I think people that have a problem with the style wouldn't want their defense lawyer to be a milquetoast when they're cross-examining people. I think they want their defense lawyer to be out there fighting and going for the throat when it's appropriate, and he has, so I think he's done a great job. I don't have any complaints with the way he's doing it.
Yeah, and I figured that would be your take on it, and that's mine too, obviously. But I do wonder, and there are some people that have felt like he in the first trial, some other lawyers that we've watched that I've liked their cross, and I like their assertiveness and controlling a witness and not letting a witness dance or be slimy or try to twist words and things like that. Some of them have seen it as bullying, and some jurors are obviously not lawyers like us, so they may see it differently. And I think that's where you have to pick your spots. You can't be like that with every single witness, and you can't be like that with certain sympathetic witnesses. And when Alan Jackson, after eviscerating Kerry Roberts on cross-examination, is about to get up and cross-examine Peggy O'Keefe, John O'Keefe's mom, and he gets up and he says, "We're very sorry for your loss. I have no questions for you." I thought that was personally very effective, because was the jury going to be like, "Oh, what's he going to do here?" Like, we just saw him go for the jugular, like you said, and then he gets up and he's kind and he sits down. Now, people could say that's false, whatever, and media, for the public, whatever. I think it's effective in front of a jury to show that side of him as well, so that they don't think he's just some big jerk that's a hammer and sees everything as a nail. I happen to be wearing the perfect shirt for today's sponsor, which is 1-800-Flowers.com. And with Mother's Day coming up, we know mothers deserve the best. And when it comes to flowers, that is 1-800-Flowers.com. And when it comes to this very special holiday, near and dear to my heart, I love getting flowers and gifts for my mom and for my wife, who are the best mothers in the world, from my opinion. And I'm sure you feel the same way about your mom. So this year, I am so excited about this timely partnership with 1-800-Flowers.com, because it's right before Mother's Day. And when you order 1 dozen roses, they'll double it to 2 dozen roses. Free. Twice the beauty, twice the love, no extra cost. So don't wait. Show mom just how much she means to you with a gift that says it all. The roses from 1-800-Flowers.com are picked at their peak, cared for every step of the way, and shipped fresh to ensure high quality and long-lasting beauty. Bouquets are selling fast, so lock in your order today. To claim your double your roses offer, go to 1-800-Flowers.com/LYK. That's 1-800-Flowers.com/LYK.
Well, and you've also got to understand what kind of a trial you have here. No matter how you want to paint it, this is a trial about a violent death. Mm-hmm. This is not a trial about the fact that someone committed Medicare fraud, or that someone stole $1 million from a bank in some kind of a fraudulent scheme. That's not the kind of case you have here. You've got a case where someone's accused of backing over a guy with a car and leaving him in the snow to die. So this is not one you've got to, you don't have to prance lightly over. This is one you've got to really fight hard for. Yeah. It's the kind of case it is.
And that definitely makes a difference too. I think that's a good point. That's a good point, because it's the proper context and the proper environment for that type of cross-examination. So in the same line as the cross examination, some things that I think went well and some things that maybe didn't hit as much. And it's not all Alan Jackson. Unetti's crossed some, Elizabeth Little crossed some as well this week, but they have tried to focus a lot on witness credibility. And I think that's important. I think it's a theme of their case. So you can talk a little bit about witness credibility, but I want to talk about two kind of instances. So we've seen them go hard on impeaching something like, did she say I hit him 2 times or did she say I hit him 3 times? Did you say she said this or do you say, I believe she said this, right? I'm going to keep the Carrie Roberts potential perjury separate. We're going to talk about that after. But some of the, what I'll call nitpicking, do you think it's effective? Do you think it's too much? Do you think you have to pick your spots? How are you kind of viewing how that's going in the trial so far?
Well, I think that number one, you have to do it. There's no choice. You've got to nitpick. That's the way you cross-examine people. You find their inconsistencies. You've got to do it. But on the other hand, how effective it is in the long run with the jury is a different question, because you can nitpick somebody on statements. You can nitpick 6 witnesses, let's say, on statements. However, if there is a consistent theme that runs through those 6 witnesses and they're all saying the same thing, even though it may be a little different, then it becomes a believable fact no matter how inconsistent you're able to cross-examine. To use an example, if somebody says that the sun is yellow and you got 6 witnesses saying it's yellow, but you cross-examine them on the fact that they said it at 6 o'clock as opposed to 7 o'clock, or then yes, you've cross-examined them, you've hurt their credibility, but the fact that the sun is yellow has still been established by 6 witnesses. So that's the point here, is you can't lose sight of the fact, gosh, I did a great cross-examination. I really tore them up, but did I do something that was really effective in the long run in destroying the fact the state was trying to prove? And again, the fact here is, did she in fact hit him? And yes, maybe you cross-examined a lot of witnesses, but has there been a consistent theme of her saying I hit him? That's what Brennan is trying to do, is he's establishing the theme. He knows these people are going to be cross-examined. He knows these people are going to get torn up with their prior statements. I mean, it was no surprise to him that, they were able to bring in their grand jury testimony. It was inconsistent with what their testimony or their prior trials testimony. He knew that was all going to happen, but he's putting on and repeating the same themes in all these witnesses so that the jury maybe will pick out, well, you know what, even though they're maybe not credible individually, maybe as a group, all 6 of them, maybe there's some credibility there, and maybe there is a fact in there that we can rely on.
And I do think
I
if you can,
hope I said that clearly. I hope
well, I think
but
the best point, it was a little long as some answers are.
okay.
It's funny. It's like the hardest thing having multiple lawyers talking on a podcast is like just keeping things tight, because I like to keep them all as tight as possible. But people love when you go on and explain, and they love to hear how you think about it. So it's perfectly fine. It works great. But the best thing I think that you said that I don't say enough when we're breaking down these trials is they have to do it. How effective is it? Maybe not as effective as they want it to be, but they do have to do it because you have to have something to cross on. You can't just let a witness say whatever. And if you can attack and chip away at their credibility, that's really important, especially if you can chip away at all their credibility so that at the end, in closing, you can say, oh, listen to all these inconsistencies that they had. And you can really build on that. And that, I think, is important. And I think that was a really good point. That's number one. Number two, that's why I do always say you've got to be careful and try to avoid the clunky, meaningless nitpicking. Like if you've got to go back and forth 15 times on a prior grand jury testimony and over one word and they're misunderstanding and it takes 10 minutes and it's all for no big hit, that's a miss. So you have to keep it tight. You have to ask the exact question you asked before, the exact question you ask now. So it takes 2 seconds to impeach on something simple, not 20 minutes, because you can really lose the effect of the impeachment if it's really clunky, in my opinion. Now, if it's a jugular impeachment, like potentially Carrie Roberts, who said Karen Reed said something and she heard her say it with her own ears, versus somebody told her Karen Reed said something, they made a very big deal about it. Carrie Roberts admitted that what she said to the grand jury was an untruth, and that grand jury testimony potentially led to the indictment against Karen Reed, that's a huge deal. That's a big deal. That's a big problem. What did you think about that when you heard it?
Well, I guess how important is the statement? That's the thing I was trying to gear. And you may be able to
Well,
tell me
it's
more and
incredibly
explain.
important if you get to the how long and then she stopped herself. Because if Karen Reed said to Google how long to die in the cold
Right.
in the morning hours versus if Jennifer McCabe Googled it at 2 a.m., that's a huge difference in the case with the conspiracy. She didn't end up going that far, but she does say how long and then stops herself. So I do think it is important if she heard it when she heard it herself versus Jen McCabe telling her what to say and what to testify to.
Now, what's Jen McCabe going to say?
She's going to say Karen Reed said, Google how long to die in the cold, that it was like 5 or 6 a.m.
See, when Karen, if when McCabe testifies and she testifies to that, I think it's going to lessen the impact of the cross examination of her saying that I heard her say it, as opposed to McCabe told me that she
And
said
maybe
it.
I'm too like deep into this case, and you can tell me what you think. But the difference is Carrie Roberts is generally um, impartial. She's not connected to everybody prior to the case as much as she is now. Jen McCabe, on the other hand, her husband, in laws, kids, everybody is at the center of what the defense is calling the conspiracy. So if Carrie Roberts said Karen Reed said it, there is a difference than Jen McCabe saying Karen Reed said it, especially because Jen McCabe is the one who Googled it, not Carrie Roberts. So did Jen McCabe Google it on her own because she left John O'Keefe in the cold? Or did she truly Google it because Karen Reed told her to? That's
Well,
the big question.
my understanding is the way that it came about is they got together and went through a timeline together,
When
and
you say
so that
they, you
I'm
mean
talking
Carrie
about
Roberts and Jen McCabe. The
yes.
next morning.
Right. That they
Right,
got together, and that's where the information came from. That was it. Roberts, is that's the name of
right,
one testified, right? Roberts. That's when Roberts testified about, and where she got the information was where they sat down and they coordinated
right.
between the two of them. Now that's pretty damaging. That they sit down and they coordinate the testimony, and then Roberts comes in and testifies to it that way. She tried to explain it, but she did testify to it that way. So that's significant. And frankly, I don't know if that is such an important fact, uh, because how long does it take? I don't know. I don't know if that's such an important fact or not.
Well,
I just don't
I
know.
think you're
Maybe
under
it's because I don't know the whole case,
right,
all
right.
the
Well, I
testimony.
think we'll see how it comes out with um we'll see how it comes out with the Jen McCabe testimony, and we'll talk about it again. But let's talk
Yeah.
about perjury now, okay? Because a lot of
Okay.
people were saying it was perjury. We asked the question, talked through it. I didn't think it was something anybody would ever prosecute for perjury. So the question was, what did Karen Reed say that you heard? That's what Lally asked her in front of the grand jury. She said that stuff, whatever. In trial, she says, I misunderstood the question. I thought he said, what did you hear that she said? Meaning somebody else could have told you what she said versus I heard it personally. She admits it was faulty. She admits it was not true, which she said to the grand jury. So people are saying lying under oath, which I understand why they go there. Two different under oath statements. One you admit is not true, but do you think that's perjury and why?
Well, first off, witnesses constantly, I mean, there's even a rule about prior inconsistent statement. There's a specific rule about that. Witnesses constantly are impeached, is the word we use, with prior inconsistent statements. If we charged everybody with perjury that made a prior inconsistent statement, there would be thousands and thousands of perjury charges. The real key is the intentionality of it. Was it intentional? And can they prove beyond a reasonable doubt that she was intentional in the way she said that? I think that's going to be very difficult. Plus, let's be practical about it. I have never in my life, and it happens all the time, seen a prosecutor charge a witness that is their witness with changing their testimony. I've never seen it because they're not going to prosecute their own witness for changing their testimony. It doesn't happen. So there's no sweat here for Ms. Roberts on that perjury count because the prosecutor's office is not going to charge her because she was a key witness in this case, and she helped them. So they're not going to charge somebody with perjury that's helped them try a case and help them to attempt to convict somebody.
Yeah, and that's just not. We have seen people change their testimony significantly more than
Oh,
Kerry Roberts did. And I think that's the unfair thing that we bring to the table is in our minds, we've seen how it works. But people hearing that she admits it wasn't true, and I understand where they're at. And I also think it's a good point you brought up. Like, we have all these rules with inconsistent statements, which in fact proves that every inconsistent statement is not perjury. Because if it was perjury, we would just prosecute everybody for perjury. Now you have a conviction of lying under oath. You perjured yourself, so there'd be no impeachment. There'd be no rules for inconsistent statements coming in. It would all be perjury, right? And of course, we know that's not how it works. All right. The next thing I want to talk about is what order do I want to go? Let's talk about John's mom testifying. A bunch of people asked, why would they even call her? She didn't really testify to anything. What did you think about strategy as a prosecutor calling Miss O'Keefe to testify?
well, my understanding is she didn't testify in the first trial. Is that right?
Correct.
Big mistake. Uh,
Well,
you
wait. Big
for
mistake.
her,
You got to define what you mean.
big mistake to not have her testify
Correct.
in the first trial. Um, uh, they must not. Again, I don't know all the details of the first trial, but they must not have tried to humanize Mr.
So,
O'Keefe in that first trial like they're doing in this trial.
so they did call his brother and I believe his sister-in-law and some of his friends in the first trial. We'll see who still gets to be called. Right, we're only 4 days into this, but they did call some family members, just not his mom. If you want my guess, she didn't want to be called. She was very. You could see she was very nervous, very sad. She was not on the stand very long. They didn't ask her very many questions. She didn't really say much, even to the questions that they did ask. But the point is, everybody picked up what she was putting down, and I think it was effective
Sure.
to humanize John for the jury.
And sure, and they dared Jackson to cross-examine
Right.
her. Please cross-examine her, Jackson. Please cross-examine her. He didn't fall for it, but they dared him to cross-examine her. And in his opening, Brennan talked about the niece and nephew that he's, I guess, adopted or he's taken in to care for. It's
They
very
testified the first trial too, and I
right.
think they might testify this trial as well.
And so I'm saying it's very important to humanize the victim in this case. And I think putting the mother on was a great idea, and they should have done it in the first trial. I don't know why they didn't. Oh, they also asked her about a conversation she had with. I mean, she had something to say about her contact with Miss Reed and,
Yeah,
and
yeah.
conversations with Miss Reed. She
I
had a couple.
understand it wasn't like overly probative.
No, but she had a couple things to say.
Okay. Next is the clips that they are playing of Karen Reed from the documentaries, all of the statements that she's making. We've talked about this in the past. We didn't know why she did it. We would have never had our client do it. What do you think about the way Brennan is presenting them? Do you think they're effective? How damaging do you think they are to Karen Reed's case? And then I have some follow up questions after that as well.
Well, from my understanding, and it seems what I've seen so far, Brennan is doing it in pieces. He's going to do some of it now, and he's going to wait a little bit, do some other stuff, then do some of it, some more, do some. So he's trying to do it chronologically, and how it fits into his case presentation, as opposed to playing all the clips and showing everything at one time, which I think is the right strategy. Uh, so he's doing that, and so right now, like you said earlier, he's painting a picture of Karen Reed being a generally bad person, a drunk driving. I think, if I remember right, she admitted although she said she could drive, she said she shouldn't have driven. Statements like that. Her inconsistencies in watching a video of her drinking as opposed to how she tries to characterize the drinks as weak, which is why she put in additional vodka shots. I mean, statements like that. So, basically they're characterizing her of what she was like that night. They're also interestingly characterizing, using this to characterize um, some people saw the couple one way, and you look at the text messages, and the couple is another way. So they're showing a conflict in the personalities of how they really are getting along and how they are as a couple. And I thought that was interesting, and he's doing that early on. And again, we have 6 or 8 weeks, but he's doing it on so the jury knows that they may seem one way in public, but in private they may be another way. And I think that's important because I think that goes to the prosecution's theory of what happened that night.
Yeah, I think that lesser experienced lawyers or prosecutors may have just played them all at once. They may have been bullied into doing something a certain way because this seems like you're asking for something extra for some reason. Um, the defense also stipulated to and did not make him call Gretchen Voss, the interviewer, any of the interviewers. They allowed him to just play the clips like this. They have argued, and Alan Jackson, I think, argued in opening that some of them are going to be out of context, or even when he's asking questions, he tries to say that these clips are taken out of context. How effective do you think it's going to be for the defense to say, oh, this clip was taken out of context? And what leeway do you think there's going to be for the defense to play clips? Because you can't play self serving hearsay, you can't play statements of your own client, but to be able to add context for like a rule of completion type of argument, do you think they're going to be able to play other parts of the clips to be able to add context to what the prosecutor has provided?
Well, I definitely think they're going to be able to do that. Again, this is a real discretionary issue with a judge. A judge has a lot of discretion when you talk about the rule of completeness and whether or not they're able to put these statements into context. So, you know, this is going to go a long way to seeing how this judge really looks at the defense case and how she's going to treat the defense when they put their case on. But they should be able to put on anything that goes to putting any of these statements into context. And another thing you raised when you were talking that I've noticed, and I've seen some of the first trial. These two lawyers have made decisions to not jump up at every opportunity to object to anything that's going on. It is obvious to me that they have decided to let each other try the case and to try the case like now they're going to not. It's not going to be unlimited. I mean, obviously they are objecting, but a lot of the things that they could object to, they're letting slide because they really realize, okay, it's not really worth objecting. Let's just sit there and let's just try this case. So there are going to be a lot fewer objections, I think. And I think the objections that are coming are going to have a particular purpose. They're going to find that they're important. That's why they're objecting, not to just small things. So they're going to let each other try the case. So like you said, they have waive their right to require these interviewers to come in or require some of the basic background in order to prove the authenticity of a particular tape or a particular item. That was a tactical decision, and I think it was the right decision because those things are meaningless to a jury. So why should they waste time and drag this trial out? It's going to be long enough without them having to put that stuff in. So you've got some
Well,
conscious decisions to do that.
Well, a couple of things with that. Number one, I definitely think that makes it look like Hank Brennan is presenting a better case, a cleaner case, a quicker case. And I definitely think there were some jurors that were annoyed at Adam Lally round one that are not going to be annoyed at the way that Hank Brennan is presenting the case because he's keeping it moving. He's not droning on about unnecessary background information. Lally did handle a witness today, Friday. And that was interesting to see him finally get up and do something in the trial. But I do think that that's interesting. I also think some of the things we were like, why are they filing these pretrial motions? This is usually something we handle in trial. Why are they doing X, Y, and Z? I think a lot of those pretrial motions and arguments have made it a cleaner, quicker trial as well. Would you agree with that?
Well, absolutely, absolutely, and yeah, they've got some of the I don't want to call it garbage, but they
Yeah.
got some of the stuff out of the way so
Yeah.
that they don't have to drag the trial on, and they don't have to inconvenience the jury. And jurors do get irritated, And so they don't have to inconvenience the jury. Plus, the judge gave them more attention if they do it pre-trial, because during the course of a trial, judges don't like to delay trials and don't like to keep jurors waiting in the jury room. So the judge will probably rush through some of these motions to get them done. So they probably got more judge attention if they did it before the trial.
I completely agree. I completely agree, and got a more well reasoned and thought out answer and order on it. Okay, last piece of evidence I want to kind of talk about is the text messages, because last trial I think they read them all basically at once. He's doing the same thing here. He's calling Guarino back in when they're relevant, when they fit into a case, when they. It feels like sometimes these videos and text messages are impeaching the defense attorneys and the points they're trying to make on cross. They'll come back and be like, "No, everything wasn't hunky dory. They were having some problems. They were having some arguments." And I think that has been an interesting way that he's used the text messages. How have you think that has gone?
Oh, excellent. Because you've got, a lot of this thing is you got to prove that, they weren't all lovey-dovey. If the jury is left with the impression that, oh gosh, I don't know how this woman could have run over this guy. I mean, look at the love and affection they have. And you had witnesses talking about how lovey-dovey they were. And yet I think time-wise it was, you have a lot of almost simultaneous text messages, and him not wanting to return or pick up phone calls, and him being irritated, and accusations of infidelity, and all of those things go to motive. Because jurors, even though motive is not a necessary element, jurors always look for motive. They always look for a reason that a person would do something like this. And if they can't find a reason, sometimes they find it hard to convict.
Yeah, I don't necessarily know if this is quite going to that level of motive, but what have
Well,
you thought? I meant to ask this about the videos. How bad do you think they are for the defense? The videos, the interviews that they've been playing from Karen Reed so far.
the out of context way they're
No,
doing
I'm
it.
just saying they're obviously not good, right? But how bad really do you think they are? Do you think they're horrible? Do you think they make her look horrible? They make her look like a bad person, like a drunk, like you said? Or do you think they're going to end up being not a big deal?
The defense, I'm waiting to see what the defense puts on to put them into quote context. Um, but I think they do back up the prosecution theory. I mean, I do think they do back up the theory. I mean, she dances around the head of a pin as to whether or not she knew what she was doing that night. She dances around the head of the pin about, maybe I hit him, maybe I didn't. All of those statements showing that, she didn't know or didn't know what she was doing that night. She's going to have a tough time. And again, this going into the future. Maybe she's going to testify. Maybe she's not. I don't think she is. But maybe if she testifies, she's going to have a tough time really testifying after she said all the things that she said in these interviews. So I think that is also a reason they're playing these interviews, is to make it tougher for her to testify, because I think a jury is going to really expect her. Again, we know the jury is not supposed to take into account the fact that she doesn't testify. They're going to get that. But boy, it's going to be awful tough for them to ignore the fact that she didn't testify after they hear her willing to talk to reporters and everybody else every day, but she's not willing to talk to the jury.
Yeah, I people have been saying that they think this is going to make it more likely she testifies. I was like, no way. Like this all makes it. I would be shocked beyond even most cases where I don't think criminal defendants are going to testify. I would be absolutely shocked if she testified. What do you think?
Yeah, I don't think she's going to testify. If she does, she's going to have to say some things that are inconsistent with her interview. She's going to have to say that she remembers what happened that night, and she remembers this, and she remembers that. Things that in the interview she seemed to kind of hedge on whether or not she did remember it.
Yeah, yeah. I think that's yeah. We'll see how it kind of plays out, because we know the science, at least from the first trial, proves he wasn't hit by a car, which makes most of what she says irrelevant, or at least it should when you have that huge of a reasonable doubt. But if the jurors hate her early on, that's not a good thing. And, we don't know what effect it's going to have on each individual juror.
And I've got to be honest with you. in this kind of case, I just don't think her testifying will help her.
I
I
agree.
don't think that she can. I don't. If the jury believes she's guilty, her testifying is not going to change their mind.
It's not
Uh,
like hers. We the jury knows that she would say I didn't hit him with my car. Like
right.
the jury knows that, and that's really all she can say to help herself at this point.
Yeah. So I don't think her testimony is going to make the difference. And if it's not going to make the difference, why take the chance?
Okay. The last thing I want to talk about was the jury view, which happened on Friday. What are your thoughts generally about a jury view? Do you think they're helpful, hurtful? They were able to make opening statements and say what they wanted the jurors to kind of focus on. What did you think about that?
The jury view thing was interesting because they do it a lot different there than I've ever had in any jury view that I've had. And I was thinking today back to the O.J. Simpson case when they went and they actually went to O.J.'s house and they walked around.
And they
No
set
one
it
was
all up.
allowed. What?
They set it all up with pictures and whatever.
Right.
Yeah.
Right. Yeah. But no one was allowed to say anything. People weren't allowed to point out, okay, this is where this happened and this is where
Well,
that
they're not allowed to
happened.
do that here either. They're not allowed to. Okay, sorry. I thought that's what you were saying. They're
No,
allowed to
no, no.
point to that's the flagpole, that's the fire hydrant. They can't say this is where his body was. They can't do that.
Right. I mean, I know that, but they were allowed to communicate. And in the OJ case and in all the cases I've ever had, you can't say a word. You just let the jurors walk around and let them have their own memories of what they see. And normally jury views come at the end of a trial
That was going to be my
after
next
they.
question. So hold
Okay,
on.
good.
Let me ask
Uh,
it here because I'm glad you're going there. Is this too soon? Do you think it should have been later? And the fact that it's this soon, who does that help?
the fact that it's this soon, uh, who does it help? That's a good question. It's tough to answer because, frankly, I think the problem with this is the value of this jury view. Is it really valuable at this point? Because the only facts they know are the prosecution's facts. So if they're going to walk around now, they're only looking at the prosecution's facts or what they've been told by the prosecutors. They do not have the defendant's theory of how things happened. So if I were to guess, I would say probably prosecution, but actually, I just think it's way too early.
It does
Uh,
feel like it's too early because they haven't gotten everybody testifying to where his body was. That everybody walked right out that front door, right by where his body is. Those are like where his body was in connection with the flagpole. Those type of spatial things, where the car was. Like the witnesses haven't testified to where her car was parked on the side of the street. So I don't get why they're doing it so early. Maybe there's a motion I missed or something like where the judge said they had to do it early. I don't get why they're doing it this early. And who does it help? I don't know, but I definitely think it would have helped the defense more if it would have been later. So I guess technically I would say it's better for the prosecution.
right, I would say the same, but it was really, I think it's kind of strange where this is in the case. And again, the fact that they could say things because they had like opening statements before they went
Yeah.
there, where both sides could give a little speech to the jury before they went. And then while they were there, they were allowed to say some things, again, which is shocking to me. But at the end of the case, it would have been better because at the end of the case, the jurors then would have said to themselves, I have questions.
Right.
I have questions about where things were or spatially how things were set up, and I can now answer those questions. But if they have later on when the testimony comes out and they say, "Gee whiz, you know what? I wish I would have known to take a look at this or known to take a look at that," because jurors are thinking people, and you can't predict everything a jury is going to think or every question a juror is going to have. So later on, they may have some questions about the location, and it's too late. They've already seen it, so they're not going to be able to take a look at whether there were 3 or 4 steps in the front porch, or how hard it would have been to carry a body from inside the house to outside the house to lay it in the driveway, which is one of the theories that we're going with here. So I this was really a shocking time to actually take a jury out there before they actually have all the evidence.
So some people think that you do it this way so that you as the testimony's happening, they have a picture in their mind. They know what it looks like. They can reference it from what, they've already seen.
I think that's the job of taking pictures and putting pictures into evidence and or they could go out there and take a video of the house and put the video into evidence. The prosecution can put a lot of things into evidence so that they can take a look at pictures and videos and all that before they go out there. I don't think they need to. I think that's what they should have done, is just taken a look at some pictures and video and not did the view until after they had all the evidence, both sides' evidence.
Yeah. It's interesting. All right. Anything else? Any other observations from week 1? What have you thought about Brennan's pace? What do you expect to see here in the coming weeks? Any other thoughts before we go?
Well, according to we don't know what the schedule. The judge has a schedule apparently, and the judge said we are on schedule when she finished on today. So they're on schedule. So they're doing and they're moving as fast as they can. I think that they seem to be moving at a reasonably good pace. Mm-hmm. I've got to be honest with you. I've done many hundreds of trials, and so their pace is pretty good. They're getting through witnesses pretty quickly. And again, I don't know, how. I think Monday afternoon they're going to go with ARCA again. I think they're going to deal with ARCA.
I don't know if it was afternoon or morning, but they're doing a half day of ARCA Monday. Yeah,
they're doing a half day of ARCA,
not the actual testimony.
Right, they're doing a half day of ARCA on Monday. So the judge is doing things so that the jury is as inconvenienced as possible. So I think those are all really important.
Yeah. Okay. All right.
Okay.
Well, we will have you on probably in another week to get your week 2 recap. I'm going to mix in some other people that are watching that have reached out and want to talk about it too, but I'm glad we could get you in. Make sure you keep following it so you can keep giving your updates. But that's all we got for this one. Till next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.